I'd like to be heard too at some point.
Promise you everybody will be able to talk.
Thank you, Mr. Chairman. I think it is important for the record to reflect that moving forward on this nomination is consistent with 2 centuries of precedent and tradition in the Senate. Numerous Democratic members of this committee have given speeches. I see they have charts prepared to give more speeches, all attacking the legitimacy of these proceedings. And as John Adams observed, facts are stubborn things. The scenario of a Supreme Court vacancy occurring during a presidential election year is not a new thing. It has occurred 29 times in our country's history. Presidents have made nominations all 29 times. The precedent is unequivocal and uniform. When a vacancy occurs in a presidential election year, the president makes a nomination. That includes Republicans, that includes Democrats. A total of 44 people have served as President of the United States. 22 of them, half, have made a Supreme Court nomination during a presidential election year. What has the Senate done? Again, the precedent is clear. Of those 29, 19 of those occurred when the President and the Senate were of the same party. Of those 19, the Senate confirmed 17 of them. The precedent is clear for a long, long time that if the President and Senate are of the same party, the Senate, in all but extraordinary circumstances, confirms that nominee. How about when the Senate and the President are of different parties? That's happened 10 times. In that circumstance, the Senate has confirmed the nominee only twice. 2016, which our friends on the Democratic side invoke, and I understand why they invoke it. They were frustrated. 2016 was one of those instances in which President Obama was a Democrat, the Senate was in control of the Republicans. They had differing views on the kind of justices that should serve on the court. And so the election resolved those views. One example that has been pointed to, Senator Klobuchar just pointed to it, Senator Harris at the vice presidential debate previously pointed to it, was Abraham Lincoln. We are told that Honest Abe, the founder of the Republican Party, showed the example for why we should not be proceeding on this. I think it's worth noting that example misses a lot of the story. So Abraham Lincoln, in 1864, 27 days before the election, Chief Justice Roger Taney passed away. Roger Taney, by the way, had been the author of the infamous Dred Scott decision, an abominable decision of the Supreme Court. So suddenly there was a vacancy 27 days before the election. Senator Klobuchar and Senator Harris before her both pointed out the fact that Abraham Lincoln did not make a nomination in those 27 days. What both of them omitted was that the Senate wasn't here. The Senate had left. They had gone home. This was not the age of jet travel. This was not the age of commuting every weekend, jumping on a United flight. They were gone, and the Senate would not return until December. So there was no Senate physically present to confirm that nominee. When the Senate did return in December, Abraham Lincoln nominated in December a justice to fill that seat, Salmon Chase, which the Senate confirmed the next day. 24 hours later, they confirmed him. I would note also that Abraham Lincoln was in the midst of a presidential reelection, and as Doris Kearns Goodwin writes so beautifully in Team of Rivals, he was very good at assembling the political coalition he needed to win, and so he had multiple factions of the Republican Party that were splintered. Some things haven't changed from 1864. And Lincoln had multiple players that wanted that Chief Justice seat, all working really hard to reelect him and dangling the nomination out in front of each of them. So Salmon Chase had been his Treasury Secretary. Salmon Chase had been a pain in the rear to Lincoln. And as a result of this vacancy, Salmon Chase went out and campaigned like crazy for Lincoln to get him reelected because he wanted the nomination. None of that should be shocking as a matter of history. And there are many members of this committee that enjoy being students of history. But to suggest that that is somehow a precedent and that requires us not to fill this vacancy now is, well, I actually can't put it better than the Washington Post, who fact-checked Senator Harris on this claim. And the Washington Post, not exactly a right-wing bastion, the Washington Post conclusion was that Senator Harris's argument, quote, wasn't exactly true. So I recognize that our Democratic friends wish a different president had been elected in 2016. I'm sympathetic to those arguments. I recognize that our Democratic friends wish there was a Democratic majority in the Senate, but the voters decided otherwise, and so this committee moving forward is consistent with over 200 years of history and precedent.
I wonder in our time who is the Salmon Chase of the Republican Party? So many to choose from. Senator Durbin.
Mr. Chairman, I want to first thank Senator from Texas for his sympathy. We know this is different. What we're witnessing this morning and this week is different than anything we've seen. Some of us have Robert Bork stuck in our craw. Others have Merrick Garland stuck in their craw in terms of what has happened here. But I think we all need to concede that we're not in a place where we should be when it comes to the operations of this committee and of the Senate and our relationship with the Supreme Court. The chairman started this hearing by reminding us about votes that were taken, 98-0 for Anton Scalia, 96-3 for Ruth Bader Ginsburg. Ruth Bader Ginsburg's vote, incidentally, was some 6 years after the Robert Bork experience. How did we manage to put together bipartisan coalitions for people on such opposite ends of the political spectrum, whom we knew going in were very clear in what they believed? And now today we struggle vote to vote, day to day, when it comes to the filling of vacancies on the Supreme Court. I think there are a lot of explanations for it. One of the things that we have witnessed here, and I have witnessed in the time that I've served on this committee, is a denigration of the process to the point where it's almost useless. We've reached a point now where gifted, experienced jurists, legal scholars take that seat behind the table and then deny everything, refuse to answer anything. Consider that. Here we are in a situation where we ask Senator Feinstein, ask the nominee, can a president unilaterally delay a presidential election? She couldn't answer. Too political. Too political. 3 express provisions in the Constitution that spell out that that is the standard for the United States of America. She could certainly have alluded to that. I asked her as a follow-up, can a president unilaterally deny a woman the right to vote? 19th Amendment. Sorry, can't answer it. Could be case come before me someday. It even reached the point where Senator Kennedy asked this learned attorney, professor, and jurist if she had any opinion on the issue of climate change. And basically she said, never thought about it. Don't have any views. What are we dealing with here? We're not dealing with the reality of who this person is and what she believes, but some kind of artifice that we have constructed between the nominee and our questions. I would be afraid to ask her about the presence of gravity on Earth. She may decline to answer because it may come up in a case. You know, it could come before the court someday. And then I look back in history at other nominees, both conservative and liberal, who have answered questions along these lines. What was the purpose of this hearing if we've reached the point now where we really don't know what she thinks about any issues, any major issues? She hides behind originalism. She's not the only one. Many do. But won't even go to the original words of the Constitution when it comes to the transition of power. It just defies logic that we are putting ourselves through this on the notion that we are measuring a person who will spend the rest of my natural life, and many on the committee, serving on the court if she ends up being nominated and approved and confirmed. and we know that this process is really stacked. The president told us so repeatedly. Where we can't get a direct answer from the nominee, we get direct answers every day in the tweets of the president. We know exactly what his motive was in nominating this person for the Supreme Court. He doesn't cover it up. His motive was to make sure that there'd be someone on the court to eliminate the Affordable Care Act. You have been respectful of the fact that we brought all these photographs before you. I thank you. But I will tell you, they are meaningful to each and every one of us and should be to you as well. These are people genuinely concerned about the future of health care in the midst of a pandemic. They are worried that this deck is being stacked to eliminate the only protections they have at a time when they're facing a life and death scenario every day over masks and their conduct as citizens. And to think what this president has said, one of the members of the committee said, "I'm not going to vote for anyone until I am certain that she's going to overturn Roe versus Wade," and then announces, "I'm voting for her." Well, now we're getting the deck stacked again as to what we can expect. The president has said as much. And then, as a grace note, the president adds, we need to be sure we have 9 justices on the Supreme Court in case there's an election contest. My friends, how obvious can this be? We know what the president had in mind when he came up with this name. Now, she may deny it, but she's denied that she even has a view on climate change. I'm really at a point now where I have to say we have to really believe what the president said. He picked a nominee that he thought would achieve his political goals. And we are breaking the rules of the Senate, breaking the rules of this committee. We are defying our own tradition, common sense, and the mutual respect which led to votes of 98-0 and 96-3. I don't know how we get this train back on the track, but this nomination at this moment in time is not usual, not normal, and it's beneath the dignity of this committee. We should have played by the rules, and the rules would have told us to wait, as Senator McConnell told us 4 years ago, until after the presidential election. When we discarded the McConnell rule, it was clear that all bets were off. We are going for this nominee at any price, at any cost, and one of them is the integrity of this committee.
Thank you. I'll recognize Senator Lee here in a second, but let me give you my take on what I saw. How did we get here? We're talking about things unrelated to qualifications. She talked extensively about severability and whether or not zero becomes a tax, that she would apply the law, the holdings of NFIB versus Sibelius. Did the change by Congress change that holding where you went from $1 or whatever it was to zero, but if you cross that threshold, that it would be unconstitutional? You still have to ask the question, can you save the statute through a severability analysis with a presumption that you try? As to climate change, anybody who has doubts about climate change is weird in your world. You're trying to make her something she is not. You're asking her questions about what happens if the president pardons himself. What is she supposed to say? All I can say is that Donald Trump was the nominee, not her. It's pretty obvious to me what you tried to do to this nominee. Every time you talked to her about the law, she gave you rational, common sense answers. She talked extensively about originalism and how different people can come out with different conclusions using the same process. So I personally reject the idea that she wasn't forthcoming. I thought she was incredibly forthcoming about who she is and the way she would judge. Now, the game has been, since she's been nominated, to get back at Trump, and I understand that's probably what I would do if I were y'all, because there's not much you can say about her ability to be a judge. If anybody in America is ready to go to the Supreme Court, it's Amy Barrett. If anybody in America has done the homework to be ready for this moment, it is Judge Barrett. If anybody in America has the character and the disposition to handle the job, it is her, in my view. Senator Lee.
Thank you, Mr. Chairman. I wanted to cover a couple of issues. Senator Cruz already covered the first point I was going to raise, which relates essentially to the observation that there is no indication from the historical record that Abraham Lincoln would have deferred to George McClellan on the issue of filling that seat that went to Sam Chase had the election of the fall of 1864 gone differently. None whatsoever. It's just not what happened. Secondly, the Dormant Commerce Clause has been brought up. This is an issue that's deeply personal to me and should be to every American. Look, a Dormant Commerce Clause is exactly...
We believe you.
Is actually one of the more important things the federal judiciary does. It's not entirely uncontroversial. In fact, it's been the subject of some controversy. It impacts the way that a state or a political subdivision of a state can treat an article of commerce, and whether or not it can be discriminated against based on its origin or destination out of state or outside the United States. It's controversial for a number of reasons, including the fact that it ends up affecting revenue streams that states and their political subdivisions can access and how they can access them. And it's based on an interpretation of the Commerce Clause of the U.S. Constitution, one that is often understood as providing Congress with an affirmative grant of authority to regulate interstate commercial transactions and channels and instrumentalities of interstate commerce. It has also been interpreted by the courts as creating a cause of action against states, municipalities, and other political subdivisions of states in those circumstances where discrimination against interstate commerce has occurred. This is a significant thing, and to call it insignificant only highlights the fact that there are some issues and not others that some of my colleagues want to focus on. And they've wanted to focus almost exclusively on those issues. Why? Well, I don't know, perhaps in some ways to convert this nominee and other nominees into somebody who can be measured against the backdrop of a Democratic politician. If you're looking at a Democratic policymaker, Amy Coney Barrett is not a policymaker. And as far as I'm aware, she's not a Democrat. You're upset with the fact that she won't unequivocally commit, as some other nominees have, to upholding certain sacred cow precedents. But it's not as though your observation is that she lacks commitment to precedent generally. It's just that she won't commit to certain precedents that might well become subject to additional litigation in the future. It is important, moreover, to remember that elections do, in fact, have consequences. In the election of 2014, the American people voted, and they elected Republicans to the Senate. In the election of 2016, the American people voted, and they elected Republicans to the Senate and a Republican to the White House. In the election of 2018, which I would note here, followed immediately on the heels of, frankly, abominable treatment by members of this committee on the other side of the aisle of Brett Kavanaugh. The American people in the immediate wake of that mistreatment of Brett Kavanaugh and your manipulation of these committee hearings elected a Republican majority to the Senate. Those terms for each of those senators last 6 years, not 2 years, not 4 years, not 5 3/4 years, 6 years. Those terms matter. And just as Ruth Bader Ginsburg herself noted in 2016, there's nothing in the Constitution that indicates that the president is no longer the president in the final term of his office. So too here. So too with U.S. senators. Nothing that makes us less senators, depending on our proximity to our next election. Certainly there is nothing about this nominee that can be left as suggesting that she's anything other than an extraordinarily gifted jurist, is well prepared for her service on the federal judiciary in a different capacity instead of being on the Seventh Circuit on the Supreme Court of the United States. The fact that she won't commit to certain controversial policy positions makes her more qualified for the job, not less.
Mr. Chairman.
Yes, ma'am.
Senator Leahy, I just wanted to respond to.
Yeah, we will, but let's, you've spoken. I'll make sure you can respond.
Well, both of these comments by Senator Cruz and Senator Lee have invoked my name.
Okay, go ahead.
All right.
Senator Lee, I
Mr.
promise
Chairman,
you,
I'd like to be heard.
I promise you will be.
Okay. I have nothing against the Dormant Commerce Clause, Senator Lee, But today, just like you did before, you are bringing it up for a reason, and that is to make this seem all esoteric and apart from the lives of American people. I believe that's why you're bringing this up, and that's why we're spending on your side so much time on some of these things that aren't relevant to people's lives. And I figure it's our job, since you guys plopped this nomination proceeding in the middle of an election, it's our job to make people understand how very much, if this nominee gets on the court, it's going to affect their lives. Because the case coming up right after this election is about the Affordable Care Act, where the administration, the Trump administration, has argued very clearly that they should throw the whole thing out, the Affordable Care Act. So whatever academic discussions you have about severability with the nominee, that is the case that they are making. And so what I did the last few days, and so many of my colleagues did up here, politely, was make the case about where this nominee is. She wouldn't even answer if she knew that Donald Trump's position was to try to get judges on who were in favor of striking down the Affordable Care Act. She wouldn't answer our question. So I got to look at the tracks. As I said the other day, up in northern Minnesota, we follow the tracks. We follow the tracks, the deer tracks, to see where the deer went. So all I'm left is with her tracks. And what her tracks showed me was that she blatantly criticized Justice Roberts for his argument, his legal reasoning for upholding the Affordable Care Act. She then goes and says she thinks that Scalia has a stronger argument in another case, which had upheld the Affordable Care Act, but Scalia's on the other side. She then takes on precedent that had been set for long that felons shouldn't be able to possess guns, as Senator Durbin got out. That's another track that I followed down that way. She then signs on to a paid newspaper ad that refers to Roe v. Wade as barbaric on the anniversary of Roe v. Wade. Okay, that's another track. You can have different views on the issue, but this is what I'm left with and what the American people are left with to look at the tracks. So I just don't think you can separate this from the election that we are in. So that is why I think it is a plan to talk about things like dormant commerce clauses so we can get away from what the real world repercussions are of this judge and of doing this to the American people in the middle of an election. But do I come out of this, as I said, as Justice Ginsburg would say in her dissents, that they were blueprints for the future as opposed to, as someone once said, cries of defeat? I don't come out of this for the cries of defeat. You know why? Because it's motivating more people to vote. You chose to do it in the middle of election, so let's all go out there and vote. That is what happens, because this should not be Donald Trump's judge. This is your country, I say to the American people, not Donald Trump's, and this should be your judge, not Donald Trump's judge, and they are watching.
Thank you, and I'll recognize somebody on our side after I have a moment. Just we'll keep talking here. So number one, the tracks were clear to me when it came to Justice Sotomayor and Kagan. I didn't need a bloodhound to tell me where they were going to go. I understood, based on their writings and their philosophy, they would be with a liberal majority most of the time. They have been. I wasn't surprised at all. I accepted that as the outcome of President Obama's selection. But it was equally obvious to me, Senator Klobuchar, that whatever personal opinions they have, I'm sure I didn't even ask them if they were pro-choice. Do you think it would be hard to follow the tracks of Justice Ginsburg? She worked for the ACLU. She was a prominent, progressive thought leader. She openly talked about her pro-choice views, and she had every right to hold them. And she was true to herself. And when the Senate voted, they knew they were getting someone very special, but from a conservative point of view with a completely different philosophy. And the Senate saw the same thing in Scalia. How much tracks did you need to figure out that Scalia would be an originalist? And the bottom line with Judge Barrett, like Sotomayor and Kagan, she's somebody that a Republican would pick. Republicans generally look at people of a disposition like Judge Barrett. Democrats generally look at people of a disposition like Justice Sotomayor and Kagan. Y'all have a good chance of winning the White House. I don't know where the polls are going to be.
Thank you for acknowledging that.
Yeah, I think it's true. I think the public will go into the voting booth and they'll say, okay, I've seen the kind of judges Democrats will nominate. I've seen the kind of judges Republicans will nominate. And that will be important to people. I think that Judge Barrett is exactly the kind of person that you would expect any Republican president to consider. Not because there's a bunch of money to get us there, just because of who she is, the way she's lived her life, and the philosophy she espouses. So with all deference and respect to Senator Klobuchar, this is not hard to figure out. It wasn't hard for me to figure out that Sotomayor and Kagan were of a disposition different than I have, but I trusted them in the big moments to apply the law and not turn it upside down. And they have been with a liberal majority, but I don't believe they've been activist judges. I really don't. And every time they rule in some fashion that the conservatives in America don't like, I get blamed for it. Now I'm getting blamed for everything Roberts did. All I can tell you is that I found them all eminently qualified. And if Judge Barrett decides that the Affordable Care Act can stand because of severability, I don't want you to be surprised, because it's pretty obvious to me she's thinking long and hard about that. I have no idea how she will rule. So at the end of the day, I don't own what they do once they leave here. I make a judgment. Do the people before us, are they qualified by any reasonable standard of intellect and character? And the answer is yes. How did we get 96 and 97 votes for Scalia and Ginsburg? That was the analysis, was qualifications. If we go any deeper than that, President Obama voted against Bush nominees. He said qualifications get you to like 70% or 80%. The heart is what you need to get over the line. I don't know how to do that. And when President, then Senator Obama, applied that standard, I said, oh my gosh. Basically what you're saying is I'm not going to vote for anybody that doesn't think like me judicially. And it is as the election didn't exist when it comes to judges. So to my colleagues, it's okay to have this hearing now. It's okay to vote now because, as Justice Ginsburg said, presidential terms are for 4 years. And I want every American to think long and hard about who would you like to be on the court, knowing the difference between the party preferences. That, to me, is more important today than it's ever been. And with that, I'll yield to Senator Lee.
And then I'd like to be recognized.
And you will be next. You're on deck. You're on deck.
Senator Klobuchar, you're actually making the point that I'm trying to make. The Dormant Commerce Clause does, in fact, impact people's lives. It does, in fact, impact local forms of government. It does, in fact, impact and did, in fact, impact the formation of this country. It was the economic balkanization of the states following the revolution during the Articles of Confederation that led to the need for the Commerce Clause to begin with. There are some questions as to whether or not the courts ought to have the power to create a private right of action to enforce it, or whether that should instead have been created by Congress, which we indisputably have the power to do. Now, if you, and in fact, if all of you now regard this as sufficiently uncontroversial, then we ought to do it. Let's run a Dormant Commerce Clause bill together. And we'll incorporate at least the anti-discrimination wing of the Dormant Commerce Clause jurisprudence and make it law once and for all, rather than just a judicial creation. I'd love to do that. The point is, this one does matter too. It's just, it hasn't yet become the subject of political tugs of war based on fear-mongering, based on fundraising by politicians in both parties. And yet, there are a lot of similarities there. But this is what we've reduced the courts to. And yes, this is their seat. This is the American people's seat. That's why we have elections. Those elections in 2014 and 2016 and 2018 that I mentioned matter. We've got the authority to do this. We've got historical precedent on our side. And we've also got the Constitution and the best nominee I've seen in a long time. Thank
Senator
you.
Leahy.
Thanks for watching, and if you haven't already, please consider subscribing to our channel. And while you're at it, please leave us a comment. Thank you for watching.